Hello everybody, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Listen, we all know the following phrase: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We can recite that by memory over and over and over. Why? Because that is the Second Amendment of the United States Constitution. But what does your state constitution say about your right to bear arms? Well, I thought we'd take a few minutes today and talk exactly about that. So let's spend a few minutes talking about what does the Washington State Constitution say about your right to keep and bear arms. Well, listen, before we get rolling here, you guys all know the drill. If you like this video, go ahead and click that like button down below if you want to stay apprised of all issues related to your Second Amendment rights, not only here on the statewide level, but on a nationwide level. Go ahead and click that subscribe button down below. And of course, if you click that little bell logo down below, you will be notified when we post new videos. Well, all of us in the Second Amendment community can always recite the Second Amendment from memory, and we recognize what an important and cherished right it is. However, what you may not be aware of is that every single state, including Washington State, has its own state constitution. So I thought what we'd do today is compare the language between the federal constitution and the state constitution and give you a little bit of a historical perspective about what Article 1, Section 24 of the Washington State Constitution states. A good starting point, of course, is to start with the Second Amendment of the United States Constitution. And we know this from heart, but let's take a look at it again, because the Second Amendment specifically reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." And certainly the language that our founding fathers chose to use has been the subject of some debate. The gun control agenda out there would tell you that the well-regulated militia is actually a condition precedent in order for individuals to keep and bear arms. However, I think it's very important when you take a look at the historical perspective that there weren't private police forces, there weren't United States military divisions as there is nowadays, and so militia had a much different meaning there. But of course, if the founding fathers had truly only intended for militia and members of militia to keep and bear arms, they wouldn't have chosen the phrase, "the right of the people to keep and bear arms shall not be infringed." And so ultimately the point in which we need to focus on, and I think the point in which our appellate courts have justifiably relied upon, is the fact that the federal constitution clearly states that the right of the people to keep and bear arms shall not be infringed. What many of you may not be aware is that our state constitution also guarantees the right to keep and bear arms. It is found in Article 1, Section 24 of the Washington State Constitution. And I think the language that our state legislature chose is very important. Article 1, Section 24 reads as follows: "The right of the individual citizen to bear arms in defense of himself or the state shall not be impaired, but nothing in this section shall be construed as authorizing individuals or corporations to organize, maintain, or employ an armed body of men." So I think the important distinction there in the state constitution is it begins with the very premise that we all know to be true, which is that the right of the individual to keep and bear arms in defense of themselves and their state shall not be impaired or infringed in any way, shape, or form. Now, why this language was chosen by the Washington State Legislature has some important historical context, and I kind of want to share a little bit of that with you. So Washington's 1889 Constitutional Convention includes some very special language which establishes clearly a strong right to bear arms, coupled with very strong language that reinforces the legislature's power to control or even ban private militia groups. Now, both versions of the Constitution, both the Washington State Constitution as well as the federal Constitution, have their roots traced all the way back to the Magna Carta in 1215, additionally to 17th century English law, which required citizens to form armed militias in order to counterbalance the oppressive authority that the Crown had at that point. But I think what's also very important here is the state constitution with language like ours expressly, and I should say this again, expressly mentions the individual's right to bear arms in their defense as well as defense of their community and state. So why does our Constitution have such different wording than that of the federal Constitution? Well, there is a historical perspective to that, and let's take a couple minutes and talk about that. So for most of those who lived in Washington State in the 19th century, they lived in an agricultural environment. They lived on farms, and they needed shotguns, rifles, and other weapons to protect their crops from predatory animals and things such as that. And for a very short period of time in the Washington Territory's history, we also know that there was significant tension and warfare between Native Americans and the settlers to this land. And so clearly the settlers believed that they needed firearms to protect themselves from the Native Americans. But both our territorial legislature as well as our first legislature established after statehood passed statutes which very strictly limited a person's ability to keep, possess, and use firearms. Concealed weapons, for example, were banned for everyone except for railroad detectives and regular law enforcement, and all pistols had to be carried on the hip in plain view. The popular view at that time was only that card sharks, and other low-lifers actually possessed firearms, and so therefore the society felt it would be best to ban such weapons from public use. And the statutes, of course, also prohibited the possession of firearms in places where alcohol and liquor was served, and that today still remains on our books. So it appears that Washington State was founded under the premise that the individual's right to keep and bear arms had to be strongly protected, but there needed to be some reasonable regulation as to the use of firearms which made sense to the general society. So clearly then that explains the language that we have about the individual's right to keep and bear arms. But what about the language in Article 1, Section 24 that prohibits individuals or corporations from organizing, maintaining, or employing an armed body of men? Where exactly does that come from? Well, of course, there is a historical perspective for that as well. In 1886, 3 years before statehood, the Puget Sound region was just absolutely wreaked by havoc by organized anti-Chinese riots in which citizens, armed citizens and militias were literally rounding up Chinese workers and shipping them to San Francisco against their will. It got so bad in Seattle that the mayor actually had to call student cadets from the University of Washington to help back up law enforcement during this time. Unfortunately, during this period of time, some of the UW cadets lost their cool, ended up opening fire on the angry mob, and ultimately ended up in killing 4 people. In 1889, around the same time of statehood, there was significant labor unrest and rioting in Coeur d'Alene, Idaho, which was broken up by armed militias. Closer to home, similar strikes took place both in the Newcastle region as well as the Roslyn area over near Cle Elum, and they too were busted up by armed militias, armed gangs of men who were hired by the companies to go in there and basically violently break the strike. So, based upon all of this previous violence, the state legislature went out to draft a constitutional amendment which made it incredibly clear that the individual would have the right to keep and bear arms, but that there would be significant regulation as it came to regulating armed body of men, militias, and such as that. In fact, the first time it was challenged in 1907, our state Supreme Court very specifically stated that
armed bodies of men are a menace to the public. Their mere presence is fraught with danger, and the state has wisely reserved to itself control over organized groups with weapons.
And so, therefore, the state has maintained that very strong regulatory language as it relates to militias and other armed bodies of men or groups of men employed to be armed and inflict violence on other groups. So what does this all mean? Well, what I think it means is that Washington State has chosen language in Article 1, Section 24, which makes it crystal clear that the right of the individual to keep and bear arms shall not be impaired in any way, shape, or form. While the state certainly has regulatory rights as it relates to armed bodies of men and militias and such as that, their ability to regulate the individual appears to be incredibly limited. Listen, I hope that answers some of the questions that you may have about the Washington State Constitution, specifically Article 1, Section 24, and how it relates to your Second Amendment rights. Listen, you may have more questions related to this or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we preach here all the time at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.